parents have no idea, what these platforms have been doing to us. I don't fault any parent.
This is the Trials Podcast, where we focus on the challenges the injured face and how we meet and deal with those challenges, especially in cases that are litigated. I'm Aaron Gartlan. I'm here today with trial lawyer Forrest Taylor. Forrest, what have you been working on this week?
Well, we've had a number of challenges this week, and I think a lot of our clients have latent injuries, head injuries, back injuries that may not be apparent when right after the accident, because a lot of times these injuries take weeks, months to really manifest themselves. So our challenge as an attorney is to go back through the medical records and establish the proof necessary to show causation that, this back injury or this head injury was actually caused by the wreck. And again, a lot of times the symptomatology is slow in coming because, as the injury progresses, the symptoms get worse. And sometimes our clients, don't go to the doctor right away, which is not necessarily a bad thing. But then, if months or, 3 to 6 months have gone by and you go to the doctor for the first time and say, look, I was in this car wreck 3 to 6 months ago. I've had this nagging back injury. What we encounter is that the insurance companies really fight with us on those type cases. And we really have to establish the expert medical proof to link that injury back to that car wreck. So that's always a challenge with us. And again, when you get in a car wreck, the first thing you're not immediately thinking, about insurance coverage and things like that. But those are issues that we've dealt with recently. Some of the other things that we deal with is that we're dealing with in the work comp standpoint is that if you're injured at work, Alabama law requires you to provide notice to your employer. And if you don't provide timely notice of an injury, you may not be eligible for workers' comp benefits. And again, a lot of our clients may have thought, well, I wrenched my back. It's not too bad. I'll take some and they never report it to their employer. 3 to 6 months later, they go to a neurosurgeon and they're needing back surgery. And our job is then to try to go back and help them get their workers' comp benefits. But it is very much a challenge if they've not provided timely notice to their employer in a work context.
Well, and Forrest, again, you touched on some of the things you've been working on kind of ongoing as well as this week. And I know one of the cases, there's a lawsuit about to be filed, and it involves a spine injury and also another case where there's a statement that was done earlier this week, and it's a case involving a brain injury.
Correct.
So, as a result of an automobile wreck, so you got kind of a work injury context, an automobile wreck context, the nuances around it being a work injury, also the challenges of a brain injury and a spine injury, because the gaps in treatment. Also, isn't it typical with brain and spine injuries to take multiple doctors? Oftentimes, they're being treated by multiple doctors over months and sometimes years. And part of the legal proof required that a one of the challenges in a case is we have to prove the event, whether it's a work injury, it's an automobile wreck, the event, that wreck, that work injury caused or aggravated the spine
Right.
or the brain injury specific.
Right.
So what are the, I think and you've touched on it, but are there, the challenges with specific to the brain and the spine injury cases?
Right. So typically, what we see is, if you're in a car wreck and you go to the emergency room, in, I would say 9 out of 10 times, you're treated and released. And then you're recommended to follow up, either with your primary care physician or with like an orthopedic. And so that's normally what we see. And then typically if a client goes to their primary care physician, primary care physician may then do a referral to an orthopedic doctor. And again, so if you have a back injury, typically what happens is, let's say you've got a herniated disc or a bulging disc. And as that disc continues to bulge or herniate, you get inflammation around that site, and gradually it starts pressing on nerves, which then cause the pain, the numbness, and things like that. And again, those are things that may not be apparent immediately after the wreck. And our job as your attorney is to go back through your medical records and try to establish a chain of proof from the date of the accident to up until the time we present the claim to the insurance company. And again, sometimes that can be challenging, but we can do it through medical evidence, also witnesses, and other types of documentation. But it is a challenge, and especially with things like a head injury, because it's not like a broken bone, where you can see it on an X-ray. The diagnostic tools to diagnose a head injury are very sophisticated, and a lot of times people don't have those type of tools available to them. And what the doctors typically rely on is the symptomatology to diagnose the head injury. But again, that makes those type of injuries very difficult, simply because it's something that can elude detection, diagnosis for months or years.
Well, and then isn't that compounded if there's a delay in reporting the accident or the injury, or a gap
Right.
in treatment?
Right. And that is very true, because the insurance company is going to say, well, you waited 6 months to go to a doctor, and we don't think it's related to the car wreck. And that can be a challenge in proving your case. And it is something that, from a layman's standpoint, it's not that unusual. I'm not going to run to the doctor every time my back is sore. I'm going to hopefully wait it out and it'll get better. But in the case, if you do have an injury such as a herniated disc or a bulging disc, you can't see that without an MRI or a CT scan. And again, if you wait, 6 months or so, it presents a challenge to us as far as proving, what caused it. And many times we're able to overcome that with expert testimony and, again, our client's testimony. And, the other thing we look at is, our client's medical history is very important, because you may have a standpoint of where somebody may have a compromised spine before the wreck. They might not have had any symptoms, but it was compromised, and what that does is predispose them to injury from trauma. And we have to deal with the fact that you had this pre-existing condition, but it was asymptomatic, and then the wreck, all of a sudden, because you're predisposed to injury, now you've got a significant spinal injury.
So for our clients or just injured people in general, what is the takeaway in all this?
Well,
What do you recommend?
you know, what I don't want to do is have people go to the doctor unnecessarily. But if you are injured, it's worthwhile to go out and get checked out by a medical professional. And that way you've got the documentation. And if you do have an underlying injury that is serious, hopefully that physician can pick that up, and then, you start treatment before it gets, in a worse condition. So I think the takeaway would be, if you are injured, I think it behooves you to go at least get checked out by your primary care physician. And that way, you can bring some closure to it. Hey, look, this is just strained ligaments. You're fine. In 2 to 3 months, you'll be fine. Or let's monitor this situation. And if you don't improve, typically what the physician will do will be to refer you out to get a CT scan or an MRI.
Well, and for specific to work injuries, what's the takeaway? What do you recommend?
Well,
there?
my recommendation, if you're hurt at work, you need to let your employer know, because Alabama law is very strict. If you do not give your employer notice, that is a defense to the claim. And the good thing about workers' comp is if you are out of work from a work injury, it does pay you disability. It does cover your medical record, your medical bills for the rest of your life for that injury. But if you do not give your employer timely notice, you run the risk of waiving those benefits, and you can be left without any type of anything to fall back on as far as paying medical bills or paying your lost wages.
Well, enforced again, I know these are all issues that just this week you've been dealing
Right.
with, working on.
That's right.
And we certainly appreciate what you're doing for our clients, again, especially in those cases that are in litigation, to meet and deal with those challenges.
Right.
Because, again, oftentimes we hear this term, oh, it's an open and shut case. But as an injured person in Alabama, you have to show, you have to
Right.
prove that your injuries, your damages, and that's done typically through medical testimony,
Right.
medical evidence.
Well, having done this since 1991, I could not think of an open and shut case that I've handled.
Yes.
I mean, if it was
We're
that,
still, yes,
right.
we're still looking for it.
Yeah, we're still looking for it. And so it has gotten, I think it's gotten even more difficult. I mean, just there's a lot of things that complicate our practice from a personal injury side. We have to deal with subrogation. We have to deal with hospital liens. And when I first started practicing, a lot of those things we didn't have to deal with. We have insurance plans that fall under federal law that add yet another level of complication. And these are things a lot of times that it can take us, even after we get the case concluded, it can take us months or even years to deal with that. And, one thing recently that it's been an issue for us is because we live in Southeast Alabama, we have Fort Novosel, formerly Fort Rucker. Here we have a lot of military people. And TRICARE is a wonderful health insurance program. Really provides fantastic benefits. But what we see is getting information from TRICARE can take, again, up to a year. And the reason that we have to do that is that TRICARE has a right to be paid back. If they've paid medical bills for treatment related to a car wreck, they have a right to be paid back from that settlement. And getting the documentation that we need from TRICARE is just a challenge, and again can cause us to cause the case to go on for much longer than it used to. The other thing is a lot of times, like for example, TRICARE may seek reimbursement for treatments that are totally unrelated to the car wreck. And in those situations, then we have to file an appeal. We have to fight with TRICARE to try to get those charges taken off, because our goal is to maximize our client's recovery. And again, these are things that have changed, I would say, over the last 5 years that we really have to deal with. And so, again, going back to it, there's really not such a thing as an open and shut case.
Absolutely. Well, again, we appreciate what you do day in and day out on those cases, especially the ones in litigation, and meeting those challenges. And to move forward, I'm really excited about our guest today. I had an opportunity recently, just a few days ago, to be on a Zoom call with Bill Brose regarding an update on the social media, and this was on behalf of one of our clients. But a Zoom call with Bill regarding an update on behalf of one of our clients in the social media video game addiction litigation. So, and of course, Forrest, as you know, we've worked with Bill in the past,
Right.
in specifically the 3M earplugs cases, the Juul vaping cases, as well as some of the other pharmaceutical litigation. So we're really excited to have Bill on the program today to give us an update and an overview of the video game and social media litigation.
Right. And it's just so rewarding to be able to work with so many great attorneys. And that's one thing that keeps me going, is to work with these attorneys and team up with these attorneys. And the other thing about practicing law is that, every day I learn something new. And, and I learn it from people like Bill, yourself. And, that's one thing that, again, it just makes, the practice of law an exciting adventure, is that, it evolves, and we're always learning new tools to help our clients.
Yeah, Forrest, I agree with you. It's one of my favorite things, or one of the things I enjoy the most about being a lawyer, is the people that I work with day in and day out, and getting to know them and work with them. Hello, good morning, Bill. How are you?
I'm doing good. How are you, Aaron?
Great. Listen, we really appreciate it. We're excited to have you here with us today on the Trials podcast. Bill, Forrest and I know you, and we've always appreciated the opportunity to work with you. I know we worked together with some of the 3M earplugs cases and the vape cases, and some other cases over the years. So we know you as Bill, but would you give us some background, introduce yourself, and tell us, what got you into law?
Certainly, yeah. I'm up in Birmingham. I'm with a firm here, Henniger Garrison Davis. We have 18 attorneys now, a good number of support staff. I've been working with this firm for a little over 20 years, and it's my second career. Prior to this, I was a nurse, and I worked in various hospital settings throughout Birmingham in various roles, and in hospital administration and in clinical research. But I wanted to do something different. Again, helping others, and it just made sense for me to go into law and to do what I do in law.
Bill, what got you? Again, I'm familiar with what you do day in and day out, but what got you from law to where you are now, and specifically working in the mass tort cases?
Yeah, good question. Yeah, and you know, I'm a plaintiff's attorney by nature, just like y'all, and you know, I got into doing mass torts, and I guess what are mass torts? It's a case where you may have 10 people or you may have thousands of people that have similar types of injuries related to a defective product or a pharmaceutical or some other type thing where numbers of people have been injured. And it's just something that really got my interest doing. We were able to help people all over the country. Over the years, we've helped people in all 50 states. We've settled cases for thousands and thousands of individuals in different cases. And again, it's a case. A mass tort's a case where a number of people will have similar injuries, and we can sort of put everybody together. But everybody has their own case. It's not a class action, but it makes us more efficient in working together on numbers of cases and hopefully resolving them all.
Well, Bill, I know you've been doing that for years now, but do you remember your very first mass tort case you were involved in?
I sure do. It was, boy, I'm going to date myself. It was FinFin. It was the diet drug litigation.
Yeah.
That was a number of years ago. Um, it was a product made by some big companies that unfortunately caused heart problems in a large number of people, men and women, that were taking this medication to lose weight. It was marketed as a great way to lose weight, and unfortunately, it caused valvular heart disease. And actually, we were down your way a lot. We were um, fortunate enough to be able to test people to see if they had these heart problems using different machines. We have physicians come in and help, and an interesting way to get started in the mass tort arena, if you will.
Bill, kind of following up on some of the cases that you've handled, could you talk to us about what the most challenging case you've been involved in?
Yeah, that's a good question. And we've had so many. Anytime you're going up against these large, powerful pharmaceutical or medical device companies with deep pockets, it's a challenge. I think one of the most challenging and most rewarding cases was involving a medication that women used to help treat migraines and seizures and things like that. And during pregnancy, they were using it. They were told it was safe. The company said it was safe. Unfortunately, a lot of the babies born to those women had very life changing defects, particularly of the spine, the spinal column. Um, Very rewarding to see what we were able to do. It took many years. That was probably the longest case we worked on. I think it was about 11 years. And to ultimately get some kind of justice for those babies that were injured. A lot of them, then they were much older than when we started the case, but we were able to see some how we were able to impact their lives.
Well, Bill, you've just touched on it, I believe, but what are the biggest challenges your clients face in the with the mass tort cases?
Another good question. Yeah. And I guess something we tell them up front is it's going to take a long time. Unfortunately, it's not a single event case where traditionally you can get it resolved fairly quickly. We have to be patient. I know it's frustrating. It's frustrating to our clients as well. They have to be committed, for the long haul. They have to also be committed to, to share things that might be real personal to them, depending on the type of case it is or the injuries. There's a lot of things that very difficult to share. Again, depending on how how the client was impacted.
Well, now, Bill, what about from your perspective as the lawyer handling these mass tort cases? What is your biggest challenge?
I think one that we look at daily is communicating in the most effective manner with our clients. It's easier when you have one or two clients to deal with. It can, the more you have, it can be more difficult. We do a lot of things to try to keep clients updated on cases. We have a nice client portal, similar to when you go to the doctor's office and you have a portal to allow you to see what's going on with your case. We are doing town halls with our clients. The implementation of Zoom technology and video technology has really sort of improved that because our clients are all over the place. Um, so we try to give the clients the one-on-one care that they deserve. They're entrusting us with uh, a case that's often life-changing to them, and we're doing everything we can to make the experience good for our clients, and it can be challenging.
Well, Bill, we really appreciate that. And I know our clients do as well. I can say from personal experience, again, we've had the opportunity to work with you in the 3M earplugs cases, a vape case, as well as some other pharmaceutical cases. And that's one of the reasons, again, one of the things that we appreciate about working with you. You're always willing to talk with us, talk with our clients, come over and meet with our clients. So we certainly appreciate that. Now, recently, and this is an example of what you're talking about, I had the opportunity to be on a Zoom call regarding the social media video game addiction litigation. Had the opportunity to be on a Zoom call with you on behalf of one of our clients. So, could you talk with us about the social media addiction cases? What is it? Can you give us an overview of that?
Oh, sure, I'd be glad to. Yeah, it's an epidemic, I think, and we'll look at them one at a time. But the social media cases, the more we dig into this, it's astounding what the meta companies, whether it's Facebook or YouTube or the other companies, Instagram, TikTok, they've developed algorithms or mechanisms uh, to hook our kids. And I'm focusing on kids because children are much more susceptible to this than we are as adults. Our brains have been more developed and wired, if you will, but in children, that's not the case. And I have kids from adults down to a 14-year-old, and it's something that we have to all take into account. How much time of our kids spending on this social media? What are they getting exposed to? And there's studies out there now that show long-term exposure over time. It could be several hours a day or a number of hours a week can cause different mental health issues in our children, and also certain physical conditions. A lot of the folks that we're looking at, they have diagnoses of mental health conditions such as depression, anxiety. Um, they have health conditions, other health conditions as well. They have problems with eating disorders. They have uh, low self-esteem. A lot of them have uh, uh, suicidal ideations, if you will. So that there's a wide range of conditions that have been linked and associated with social media. And when you're going against big companies like these, these are very, very powerful and have a lot of money. Uh, you network and you work with other law firms across the country, and it becomes much more efficient. And cases then are centralized usually before one judge or one court, and that's happened with the social media cases. They're actually centralized before a judge and a court in California. Not uncommon, and clients then say, "Well, I'm here in Alabama, or I'm in New York. How does that work?" It works that way. I mean, it doesn't seem like it does, but your cases are centralized, and hopefully they'll be resolved there in the California court, and hopefully all the cases will be settled there. If not, sometimes we have to come back to Alabama and work the case up there. But in social media, that's what's going on, man.
So, Bill, those cases have been centralized right now in California. So, as lawyers, it's kind of second nature to us. Like, um, I guess the conduct, because we get this, and I appreciate the overview, but I guess what I'm getting at is what is the legal. Can you give us an overview of what um, the liability component to the case? Like, what are you looking at there?
Yeah, a good question. And yeah, we get into the legal, various legal claims, and the with social media, especially, a lot of the claims centralize on negligence and what the company knew and did not disclose to parents and to children that are on these platforms. It's a product, so there's talking product liability and things like that. It's there's a lot of components, I guess, to what goes on. But the as we dig deeper and deeper in what's called discovery, where we learn about what the companies knew, and vice versa, the companies are, of course, learning about our clients and how they were injured and how much time they spent on these platforms, etc. But we discovered that these companies have uh, professionals. It could be physicians, it's a neuro psychologists and all that are looking at ways to have our children spend more and more time on these platforms. There's a lot of money, believe it or not, to the companies. The more time that everybody spends on their platforms, the way they sell ads and things like that. So the more screen time that we can have with children and adults, the more profitable it is for the company. So um, those are the basic sort of types of claims that we look at, and it can be very complicated. Of course, the defendants have, as you can imagine, armies of attorneys that are doing the same thing that our side's doing, trying to get all the cases tossed out that they can. So, uh, a lot of moving parts.
Bill, I appreciate you giving us that overview of the liability, because I think with a lot of people, their thought is, well, isn't this the parent's responsibility to monitor this? But as you pointed out, when we're talking about children and the again, the issues that are that you're focused on with the liability, um, it's isn't it a little bit more complicated, more complex than just, hey, this should be the parent's responsibility to monitor?
Oh, for sure. And to be honest, as a parent too, I guess this brings it more to light. Should we have more responsibility monitoring these things? Um, and I don't know the answer to that. It's very, very tough. Um, Parents have no idea, what these platforms have been doing to us, I don't fault any parent for not paying more attention to what their children are looking at. That there's no real regulation out there, into what these platforms can and cannot do, and it's a complex matter. It's frustrating. It's frustrating to us. It's frustrating to our clients and our parents. And the more and more that we meet with our clients and their parents, it's heartbreaking to hear, the stories that these children, I call them children, young adults, are having. How they're addicted to these devices. And as a parent, there's certain things that we have to look for. A lot of it, a lot of these children tend to isolate more. You see their grades change as they become more and more entrenched in these platforms. They're not spending time on their studies. Um, but it's things that we don't associate with the social media platform. And I think the public is becoming more educated on this, over time. So I think there's still a lot of work to do. And again, it's not a parent's fault. about what's happening here.
Well, Bill, um, we hear people talking about the algorithm and uh, terms like that, and I guess what I wanted to just maybe summarize here and anchor this point down a little bit. Are you saying that the that there's experts that are looking at ways essentially to work that algorithm, the feed, whatever the case may be, to keep a child on the platform longer and to specifically send them things that's going to keep them on the platform longer, even though we know if they're on the platform all day or for hours at a time, it's going to cause these psychological and social issues. Is that, I know that's oversimplifying things, but is that basically what you're finding in these cases?
It is, and yes, the companies are, and I don't think their intent is to cause harm, psychological or physical harm to children or adults that watch these. But yeah, they they can monitor and track your patterns. What do you like to watch? Specific things. Who do you like to interact with? A lot of these platforms have an infinite feed, and you mentioned feed a minute ago. Scrolling, an infinite scroll. You can't get to the end of it. You can just keep going and going and going. Um, there's a lot of overlap between social media and video gaming. Video gaming is even more intense because they follow you as you're playing these games, and there's you know, a whole bunch of different games and different manufacturers out there as compared to the social media. But they reward you as you're playing these games. They'll intentionally give you a reward so you feel like you're doing better. You go to another level. You find another item, that you might need as you progress. Uh, and embedded in the games, there's the financial aspect too. A lot of these kids are spending money. Unfortunately, the parents don't find out till later. They're spending money on these games as they go along. They're getting rewarded. They're getting rewarded when they do well, and they may even be placed in games with other players that may not be at as high a level as them, so they feel like they're doing much better. I think there's a whole lot. I think we're just touching the surface about what a lot of these designers have done and are continuing to do.
And Bill, would you say that, and it's something as plaintiff lawyers that we look at in cases, but this whole concept of you touched on it, that it's not that it's an intentional thing to hurt anybody. It's the financial. It's the financial the financial gain to keep the kids on the platform or in the game spending money. So we kind of get into that profit, um, safety kind of balance, the balance between, you know, the profitability of it and, on the other hand, the harm that it's doing.
Exactly. I think you hit the nail on the head there. The and I can go into statistics all day, but the top three makers, for example, of the video gaming, are making billions, and that's with a B, billions of dollars a year off of their platforms. And some of these games have millions of users or participants a day. Um, they make a lot of their money from the ads, the advertising that goes with them, the market share, and of course the money that individuals spend on these games. Uh, but yeah, it's pretty disheartening, and we see it a lot. We see it here. A lot of these companies put profits over safety, if you will. It's a common theme. That we see that often also in the pharmaceutical and medical device industry, especially. Um, a lot, and I'm not faulting. A lot of these drugs and a lot of these medical devices are very necessary, and have saved millions of people. But it's not without risk. And a lot of these companies, and I know I'm sort of changing another subject, but a lot of these companies know from research and clinical studies that are going on that their drugs and devices are harming a certain percentage of the population. But I'm afraid they put profits over safety in a lot of cases.
And again, that's part of the issue with the social media and the video game, the profit over people, the profit over safety. Is that the pretty much the heart of it?
I think so. I don't believe companies start out that way a lot of times, but I think we see that in a lot of industries, and that's a central theme to this case for sure.
Well, and Bill, you touched on the development of the brain, but aren't there also studies around addiction with children, whether it's nicotine, but in these cases, being on the video games and the platforms, isn't there that very similar correlation between the development of the brain, and if they can get them in, the odds of an addiction developing, isn't it much greater with children?
It is. It is. And you're right. The cases that we look at involve children. And what defines a child? Usually, the brain is pretty much wired or developed when you reach 18 or 19 years of age. So it is an addiction. I mean, they're using mechanisms that they can. And you touched on the vaping. We did litigation around a very, very popular vape device, the Juul device, which was marketed. Although it's illegal to market to children, it was marketed directly, we believe, to children with the different flavors and the commercials that showed young people using these devices. But yeah, uh, the the younger you can get somebody addicted or hooked on their product, the long term profits, I guess, for those companies on those things is evident.
Thanks for listening to the Trials Podcast. We'll continue this conversation in the next episode. We encourage you to subscribe to our channel so that you don't miss any of our upcoming guests and also any of our new features.